Hello? Hello?
This is Zink. This is John Schultz.
Yes.
Are you ready to discuss the CR35 examination?
Sure.
Okay. What would you like to know about it? I really don't know an awful lot about it other than I asked Dr. Barnard to do one. He said he would, and he could.
But that, you do realize that the discovery here, in order to do a CR35, you have to have a reason for that. So exactly what is your reasoning? I don't know if you got my brief yet, but I have filed a response to your motion, even though you did not file any briefing with your motion. I went ahead and filed an answer asking the city to explain how this is going to produce any admissible evidence.
You have made a claim that the city has negligently inflicted emotional distress.
But that doesn't require a psychological evaluation.
In my opinion, it does, and I have cited Civil Rule 35, and that is the legal basis on which I've made my request, and I filed an affidavit with the court setting forth the answers to the interrogatories and our email train where you indicated you didn't want to have one.
Correct, and I don't.
The city is entitled to an examination.
No, they're entitled to a limited examination. You see, what Dr. Barnard... Well, my first question for you is, Dr. Barnard ever dealt with the sex offender program? Does he do sex offender evaluations?
I don't know, but that's not what he's doing here.
No, but that would definitely be a conflict of interest since I'm asking for the SSOSAs or the evaluations done for sex offenders, and he would have a good reason to be biased in his opinion. So that's why it was important for me to get a hold of him, to talk to him, to find out whether or not he was involved in these. Because if he is, then I would say that would disqualify him as a provider. Number two, I have not lost any privilege to my health records or my health issues simply because I filed a suit. And whether you think so or not, the 35A specifically states that you have to show just cause, you have to show a good reason, and you have to show that there is an actual controversy. And you're coming in and saying it's because I think that there's a controversy is not good enough. And I've put some case law in there for you in my response. And you also have to show that it is the least restrictive. Now, I know for a fact that emotional distress is not a DMS-4 diagnosis, and so therefore you would not need a psychologist to come in. Also, did you have an opportunity to review my medical records of my heart condition, the status of my heart after the arrest? Because now that is related to emotional distress.
I don't know what I can do or say about what Dr. Barnard proposes to do. Dr. Barnard told me that he could perform a CR35 examination.
Well, yes, under certain circumstances.
I don't know anything about... I don't tell him what he can do or can't do or what is necessary for him to determine whether or not he could support, and he might support your claim. I don't know. I don't know what he's going to say.
It's not up to him. It's not. This is a legal issue, okay? And have you actually done any research into case law concerning CR35?
Ma'am, I've been practicing law for 53 years. I have never seen a request for an independent medical examination denied.
Okay, well, then you need to limit...
Maybe one will be denied here, but if so, it will be a first for me. These are routine. You are making a claim for the negligent infliction of emotional distress. Dr. Barnard is in a position to evaluate whether or not such a condition existed.
But it's not a condition. Emotional distress is a normal thing that people feel, which is why Dr. Barnard needs to come in and explain to the court how I'm the only person who would need a psychological evaluation to be able to claim emotional distress. Because everybody, you have emotional distress when you get married. You have it when you get divorced. You have it when you get held up by a gun. People get it for all kinds of reasons.
Are you willing to discuss when such an examination can take place if the court orders one?
If the court is going to order one, then what I am going to do is ask the court to put it on stay until I take it up to get a mandamus to block it. Because it is an invasion of my privacy. Like I said, I think you need to go in, unless he wants to limit it. Now, if you want to have a deposition type situation in your office and he wants to come in and ask me about the anxiety and the emotional distress and the physical symptoms that came from that, then that's fine. I would be perfectly willing to do that. But I am not going to submit... I'm not going to give up my privilege to my health records simply because I want to hold the city of Mesa accountable. And also, you may want to look at that tape because you're making claims that are false. And I am going to go and do something about this because they never called Terry Tanner. It's on the tape. He was never called. In fact, they tell you on the tape, they called him a few days ago and he hasn't got back with them yet, just like I told you. It's all on the tapes. So you need to look at those tapes. So the only other, I don't see where you have any standing to ask me to have a full psychological evaluation simply because I'm claiming emotional distress. You don't have to have a psych problem to have emotional distress.
So you are unwilling to discuss the time and place of such an examination?
Yes, I am.
The court will have to order it.
Right, you're going to have to follow the court rules. And if you've been an attorney for this long, you should have known that you needed to file a brief that had legal authority for the court to act, and you can't just walk in there and say it's 35. There are rules to 35. Go look it up. Even a United States Supreme Court, which I provided you with the court's, the Supreme Court's decision that is the one that you have to follow, is the Supreme Court decision, and it's also 35A. So you can look it up, what I wrote for you.
Do you have anything further that you want to discuss concerning the examination?
What is it going to entail?
I wrote him a letter, and he wrote to me that it involves a comprehensive psychological assessment.
Which is too much. You won't get that information out of me. What about my health privilege? What are you going to do? You're not entitled to know if I have a psychological disorder. What makes you entitled to know whether I have a psychological disorder?
Because you have made a claim for the negligent infliction of emotional distress.
But that doesn't involve a psychological...
In order for me...
Okay, you're just repeating yourself. If you cannot see that you cannot ask me to have a full psychological evaluation for emotional distress, then I'm just going to have to take it to the court and get a protection order. But my intention is that if they go ahead and put that in place, then I am going to file for an appeal. And I would also like to explain to you right now that Jackie Shea Brown represented us in 2002, and so I seriously doubt when I go into court I'm going to ask her to recuse herself because she did represent us in a case in 2002.
Yeah. The court ordered us to discuss any conditions, or is there anything else that you want to talk to me about other than that you simply do not want to do it?
No, I asked you if the least restrictive, if you go by the actual law, it says that you have to come up with the least restrictive. And what I am telling you is if you want Dr. Bernard to come into your office and do depositions concerning the emotional distress I felt at the time that I was arrested and the records, which I don't believe he has the qualifications to argue against the heart records that I sent you, the discussions on the pain in my wrist, which, by the way, was a different illness, and I'm going to update you on that. And I had to have surgery in the end on my wrists. And that was from the handcuffing. Now, if he can go in there and talk about those two issues, I'd be more than happy to come down to your office and we stick to those particular issues of the emotional distress. Any other mental health issues that I have is none of your business.
Okay, I believe when you make a claim for personal injury here for emotional distress, everything is open for discovery.
No, it's not. You need to go into 26. It says that anything that's privileged is not. In fact, I'll give you the number right now. I believe it is 26. I know he knows it. He's been an attorney all these years, and I feel like you're the newbie, and I'm the newbie. 26 says that you cannot get discovery for something that's privileged. And medical and mental health records are privileged. So no, you do not have access. And also Dr. Bernard, unless he's working with sex offenders or talking about parents and their children, he cannot submit this report to the court. It's private, it's privileged, and it would have to be sealed. So there are things in that report that you would not be privy to, or else he would be violating my rights to privacy in my medical and mental health records. So if you want to arrange a meeting to discuss the anxiety and the emotional distress, that's fine. But unless you can come up with a disorder in the DMS-4, he's not qualified.
Is there anything else that you feel you want to discuss about the examination that I've proposed?
Are you just going to keep asking me the same question?
Well, ma'am, you're not giving me the same answer.
Okay, well, you tell me. You're not willing to negotiate at all. You just want to go get a court order, and I don't know where you get this idea that you're entitled to it. Perhaps you are. I'll make sure that everybody knows that. But I mean, entitled to it, and then you can just walk in. You haven't provided me any legal argument whatsoever. 35A has case law attached to it. Go look that up.
Do you have anything else?
Oh, you know what? No, I don't. I don't have anything else. I told you about Jackie Shea Brown. She used to be our attorney. I'm not going to hang up on him.
Say that again, ma'am.
I said, I told you that Jackie Shea Brown used to be our attorney, represented us in a case one time, so I don't think that she can hear this on Monday. I told you that. I told you that if you want to limit it down to just the anxiety and the emotional distress in a deposition type setting with Dr. Bernard asking the questions, that would be the least restrictive. Or you can just simply have him come in and testify. But he cannot assess, for one thing I know for a fact, he cannot assess based on today, what I'm like today, what I was like 13 years ago. But there is medical evidence of what happened, and it's documented. So you need to go through that first, and you might want to send it to Dr. Bernard and ask him if he's going to refute my heart specialist.
I don't believe Dr. Bernard is a heart specialist.
And he cannot refute. He's also not even a medical
doctor.
doctor.
Is going to attempt to evaluate whether or not there is any evidence that there was an emotional distress caused by this incident. Of course, the arrest didn't have anything to do with the city.
Yeah, it did. You need to go watch the tape. They called the sheriffs and gave false report. They had me. They called the sheriff. You know, excuse me, but the thing is,
I don't want to. We don't need. You will have an opportunity to attempt to present your case to a jury. The whole purpose of this inquiry is to determine whether or not there was any negligently inflicted emotional distress. That's the reason I asked Dr. Barnard if he could evaluate that, and he said he could.
Right, but you want me to have a full psychological evaluation.
I want you to have an independent psychological examination because you are making a claim for...
But there's no psychological... I didn't provide you with any psychological evaluation, so how can you have an independent when there was none to begin with?
Okay, we're going around in a circle, ma'am.
Okay, then I guess we're done, and we'll just go in there and talk about it. But like I said, I would submit some kind of written briefing here.
Thank you for
you bet.
my call.
Sure. Bye.